Ladies and gentlemen, let us all rise for the arrival of the Honorable Senate President and the Senators of the Republic of the Philippines.
The 45th session of the Senate and the first regular session of the 18th Congress is hereby called to order. Senator Cynthia A. Villar will lead the chamber in prayer.
Let us put ourselves in the presence of God. Dahil sa ating buong bansa, lalo na ang ating mga kababayan na lubos na apektado sa Batangas, Tagaytay at sa kalapit na mga lugar sa Calabar Zone Region, ay patuloy na nababahala at nag-alala sa napipintong pagputok ng Taal Volcano. Ating dasalin ang panalangin ni Cardinal Luis Antonio Tagle. Diyos na makapangyarihan, muli kaming humaharap sa pagsubok dulot ng pagsabog ng Bulkang Taal. Napakaliit namin upang harapin ang lakas ng bulkan. Subalit naniniwala kaming mapapahupa ng iyong kamay ang bangis na nito. Iligtas mo po kami sa kapahamakan, lalo na ang mga mahihirap, may karamdaman, mga bata, at nakakatanda at nag-iisa. Pag-itingin mo rin sa amin ang pagdadamayan, pagmamalasakit at pangangalaga sa kapwa at kalikasan. Hinihiling namin ito sa ngalan ni Jesucristo kasama ng Espiritu Santo. Amen.
Amen. The Secretary, will please call the roll.
Roll call of members, the Honorable Senators Angara, Binay, Cayetano, De Lima, De La Rosa, Drilon, Gatchalian, Go, Gordon, Ontiveros, Lacson, Lapid, Marcos, Pacquiao, Pangilinan, Pimentel, Poe, Recto, Revilla, Tolentino, Villanueva, Villar, Zubiri, Senate President Soto III.
Seventeen. With 17 senators present, the chair declares the presence of a quorum. Majority Leader.
Thank you, Mr. President. Mr. President, I move that we dispense with the reading of the Journal of the 44th Session, Tuesday, January 21, 2020, and consider the same as approved. So,
Any objection? Hearing none, motion is approved.
Mr. President, before we take up other matters, we'd like to just greet the guests that are here today with us. We have Board Member Bobot Fongwan of Benguet, a guest of Senator Bongo. We also have with us several groups. We have ASES Save the Earth from A to Z, and World Mission Society Church of God, and University Student Volunteer Group from South Korea. Mr. President, they're here with us today.
Welcome to the Senate. We welcome all our guests.
Mr. President, I move that we proceed with the reference of business.
Secretary will proceed with the reference of business.
Reference of business, bills on first reading. Senate number 1286 entitled An Act Appropriating the Sum of 30 billion pesos as supplemental appropriations for fiscal year 2020 and for other purposes, introduced by Senator Recto.
Refer to the Committee on Rules.
Communications, letters from the Office of the President of the Philippines transmitting to the Senate 2 original copies of the following Republic Acts, which were signed by President Rodrigo Roa Duterte. Republic Act Number 11462, an act postponing the May 2020 Barangay and Sangguniang Kabataan elections, amending for the purpose Republic Act Number 9164 as amended by Republic Act Number 9340, Republic Act Number 10632, Republic Act Number 10656, Republic Act Number 10923, and Republic Act Number 10952, and for other purposes. Republic Act Number 1143, an act establishing malasakit centers in all the Department of Health, DOH hospitals in the Philippines and in the Philippine General Hospital, PGH, providing funds therefore and for other purposes. Republic Act Number 11464, an act extending the availability of the 2019 appropriations to December 31, 2020, amending for the purpose Section 65 of the General Provisions of Republic Act Number 11260, the General Appropriations Act of Fiscal Year 2019, and Republic Act Number 11466 entitled An Act Modifying the Salary Schedule for Civilian Government Personnel and Authorizing the Grant of Additional Benefits and for other purposes.
To the archives.
Letters from the Bangko Sentral ng Pilipinas transmitting to the Senate copies of the following certified and authenticated BSP issuances in compliance with Section 15A of Republic Act Number 7653, the New Central Bank Act. Circular Letter Number CL 2019-084, 85, 86, 87, 88, and CL 2020-001 dated 22 November 2019, 19-23 December 2019, and 2 January 2020. Circular numbers 1061, 1062, 1063, 1064, 1065, 1066, 1067, 1068, 1069, and 1070 dated 25, 26 November 2019, 3, 4, 13, 26, and 27 December 2019, and memorandum numbers M 2019-27, 28, 29, and 30 dated 15, 26 November 2019, 12, and 18 December 2019.
Refer to the Committee on Banks.
Letter from the Union of Local Authorities of the Philippines, Inc., furnishing the Senate a copy of the ULAP National Executive Board Resolution number 2019-21 entitled A Resolution Constituting the Union of Local Authorities of the Philippines ULAP Interim National Executive Board and its interim officers to perform their duties and functions until such time that the regular NEB has been duly constituted and its regular officers elected and sworn into office.
To the Local Government Committee on Local Government. Majority Leader.
Thank you, Mr. President. Mr. President, we'd like to also recognize in the gallery our dear friend from Isabela, from Kawayan, Isabela, Mayor Bernard D., multi-awarded mayor of
Yes.
Kawayan.
Mayor and the other guests, welcome to the Senate.
Thank you, Mr. President. Mr. President, under agenda, we have a couple of bills to take up. We'll start off, Mr. President, with the permission of the body. I move to resume consideration, Senate Bill number 1083 on Committee Report number 9.
Any objection? Hearing none, consideration of the measures in order.
We'd like to recognize our dear colleague, Senator Panfilo M. Lacson, and to interpolate our distinguished colleague, Senator Risa Ontiveros.
Senator Ontiveros is recognized to interpolate the sponsor, Senator Panfilo Lacson.
Mr. President, maybe before we recognize the two gentlemen and ladies with the permission of the body, we have a group of visitors here because their interpellation may take a long time. We'd just like to put on record that we have with us the ladies of the ICA school. ICA stands for
Yes.
Immaculate Conception Academy. Alam na alam ni Pia. Although I have a lot of friends from ICA. So they're here with us today, Mr. President. Just for the record.
All right, welcome to the Senate.
Thank you, Mr. President. Thank you, good sponsor. Mr. President, let me begin by assuring the good sponsor that I'm one with him in finding durable solutions to the scourge of terrorism, which remains a serious global threat. According to the Global Terrorism Database, the annual death toll caused by terrorism stands at about 21,000 people worldwide, mostly in the Middle East, Africa, and South Asia. Therefore, Mr. President, my questions don't aim to question the fundamental rationale of bearing down strongly against terrorism. Our people do need to be protected from acts of terrorism. However, it's equally important that we don't, in our zeal, unintentionally provide tools that can be abused to stifle legitimate political dissent and criticism, remove safeguards already enshrined in our Bill of Rights, and inadvertently create uncertainty and imprecision in our laws. So to start off, Mr. President, in Section 2, I noticed that the third and fourth paragraphs of the Declaration of Policy were deleted. The third paragraph spoke of a comprehensive approach in the fight against terrorism, including post-conflict peace building and promoting equitable economic development. While the fourth paragraph, on the other hand, guaranteed that human rights remain absolute and protected. As both a peace advocate and a human rights advocate, may I know from the good sponsor why these paragraphs were deleted?
First of all, I'd like to thank the distinguished lady from Panay Island for expressing her full support to the passage of this measure, or for the passage of this measure. Yes, we decided to delete or propose to delete the second paragraph of the Declaration of Policy for the simple reason that we want the goal of this proposed legislation to focus on the empowerment of the government to address terrorism as a crime. We removed the second paragraph to emphasize the focus of law on anti-terrorism efforts. The proposed law clearly differentiates between anti-terrorism and human security. Nevertheless, let me assure the distinguished lady that all human rights safeguards are retained in the bill as these are embedded in the relevant provisions, Mr. President.
Mr. President, I welcome and thank the good sponsor for that categorical reassurance that all human rights safeguards remain embedded in the bill. However, alam naman po natin, Mr. President, at alam din po ng good sponsor as a veteran lawmaker, na madalas kung ano yung sinasabi talaga ng isang batas ang itinuturing na mahalaga. At yung hindi sinasabi, bagamat maaring sabihing embedded dyan, dahil hindi sinasabi, ay maaring ituring na hindi kasing halaga. And that's the reason, Mr. President, I asked this first question, because I'm hoping that we're not sending our people the message that we're looking at less comprehensive solutions to terrorism sa pagtatampok lamang ng law enforcement and not anymore explicitly mentioning human rights and peace. I hope we're not sending the message that we are willing to compromise fundamental freedoms in the interest of more effectively implementing law enforcement approaches, Mr. President.
That is also the reason why we did not include in any of the provisions the right of individuals, of citizens to peaceably assemble. No, wala po yun doon in the list namin. Basta't legitimate expression of the exercise of freedom of speech or expression, hindi po natin sinama rito. Wala pong punishment doon.
Thank you, Mr. President. I will get to a related question to the point just mentioned by the good sponsor in terms of the fundamental civil and political rights of our people a little later. Mr. President, in Section 4 of the committee report, in the definition of terrorist acts, the phrase, regardless of its stage of execution, was introduced. I'd like to ask the good sponsor, does it mean that an attempted act of terrorism is punished the same as a consummated act of terrorism? Dahil po in the revised penal code, the penalty of a consummated offense differs from the penalty for a frustrated or an attempted offense. Are we changing this in this bill? And if so, why?
We want to be as much as possible proactive, Mr. President. But as taken up during the interpellation of the distinguished minority leader, we're willing to take out the word attempted and instead retain the word conspiracy to commit terrorist acts, Mr. President. So, of course, we retain the phrase at any stage of at any stage, either in preparation, planning, training, etc., etc.
I thank the good sponsor, Mr. President, for that reiteration of his commitment in the interpellation of the minority leader to remove the term attempted. But perhaps at the proper time, I'll continue to try to tease out possibly alternative ways of formulating this provision to address my concern about the implications of the phrase regardless of its stage of execution. In this same section, Mr. President, Section 4, and this was also discussed by the good sponsor with the good minority leader, attacks that result in major economic loss, paragraph B of Section 4, and destroy the fundamental political, economic, or social structures of the country are considered terrorism. A threat to commit the same is also considered terrorism in paragraph E. So, dun sa pag-uusap din po ng good sponsor at ni minority leader, pinoint out na ayaw nating magpasa ng batas na may provision which may be interpreted or implemented to the point of absurdity. So let me see po. If, for example, a labor group threatens to strike or to conduct work stoppage, and said strike or work stoppage may be argued by some to result in major economic loss, even destroy the economic structure of the country, could members of this workers group, this labor group, be considered terrorists?
Meron pong proviso dito na basta't legitimate exercise of the freedom of expression or mag-exercise ng mag-express ng dissent, hindi po kasama rito, hindi mako-cover. Explicitly provided po yan sa section 4, yung last paragraph po nandyan.
Salamat po, good sponsor. Siyempre, laging sasabihin ng labor group kung magsa-strike o mag-work stoppage na
Ito po yun, if I
legitimate
may read
expression namin. Yes,
for the
please, good
record,
sponsor.
provided that terrorist acts as defined under this section shall not cover legitimate exercises of the freedom of expression and to peaceably assemble, including but not limited to engaging in advocacy, protest, dissent, or mass action where a person does not have the intention to use or urge the use of force or violence or cause harm to others. Guaranteed po yon, Mr. President.
Salamat po sa garantyang yan, good sponsor, Mr. President. Pero at gaya ng sinabi ko kanina, syempre, laging sasabihin na ating mga kababayang manggagawa, kapag ka nagwelga sila, kapag ka nag-work stoppage sila, ay ito ay legitimate expression, freedom of expression, freedom of association, yung karapatan ng paggawa. Pero kung kunyari sa welga nila or work stoppage nila, sasabihin ng Department of Labor, halimbawa, na dahil sa welgang ito o dahil sa work stoppage na to, magkakaroon ng serious or major economic loss. Or kung sasabihin na dahil sa work stoppage o welga nito, this would actually destroy the economic structure of the country. Kung ganong klaseng claims ay gawin, pwede bang magamit itong panukalang batas para ituring silang mga terorista?
Unang-una po, we're bound by the intent or motive, yung purpose po. At saka kung wala naman pong violence na mangyayari o nangyari, hindi naman po pwede makasuhan under this proposed measure.
Salamat. Thank you, good sponsor, Mr. President. Indeed, the intent, very clearly articulated also in the bill, is important. Lastly, on that question of violence, what if in the process of a strike or a work stoppage, nagkaroon ng dispersal, nagkaroon ng karahasan? We could cite a few, and our good chair of the Senate Committee on Labor could cite a few examples of recent incidents na dininig nila sa ating Committee on Labor. Kung magkaroon ng violence, not instigated by the workers, but in the course of the strike or work stoppage, could this bill be stretched to determine that they are terrorists?
Hindi po. Kasi unang-una, hindi naman yung intent eh. Ang intent ng mga nagprotesta, mga laborers, mag-strike, mag-strike, mag-express ng kanilang sariling yung dissent o yung expression ng kanilang pagprotesta sa pwedeng sabihin na natin mga bad labor practices. So hindi po papasok dito sa provision na ito. Malinaw
Salamat,
po yun.
good sponsor. Salamat, Mr. President, para sa paglilinaw na iyon. In Section 5, Mr. President, it shall be unlawful for a person to possess objects committed in the commission of a terrorist act or collecting or making documents likely to facilitate the commission of a terrorist act. So, first question about this Section 5, Mr. President. The mere act of possession of documents likely to facilitate a terrorist act is punishable or would be punishable under this act, would be punishable by life imprisonment. Is it then mala prohibita, Mr. President?
Yes, Mr. President, kasi kung maliwanag naman na may explosives, may bomba, no? Yung materials na hinahawakan nito, maliwanag ng kanyang intent para mag-commit ng terrorist acts, pwede po siya talagang makasuhan under this proposed measure.
Ibig pong sabihin ng good sponsor, parang manuals, instructional materials kung paano magbuo ng explosives.
Tama po.
To
Kung
conduct
halimbawa,
terrorist act.
manual na paggagawa ng bomba, manual na kung paano mag-operate ng weapons of mass destruction, or pwedeng sabihin natin na mga poisonous substances na ang intent ay maliwanag na para mag-sow ng terror, pwede po talaga makasuhan.
Salamat, good sponsor, Mr. President. At konektado sa follow-up question ko na what kind of materials are likely to facilitate the commission of a terrorist act? So nasimula na po nating pag-usapan yung mga manuals to conduct terrorist acts or to manufacture yung mga material sa pagsasagawa ng mga terrorist acts. Pero kung halimbawa, a person collects handbooks, say, on military matters, or even textbooks on basic chemical procedures. If a person reads Marxist or Marxian literature or materials that call for a revolution, pero purely for reading pleasure, will that person get life imprisonment without parole? Hindi ko maiwasang isipin, good sponsor, Mr. President, kung paano kaya itong provision maaaring gamitin sa mga mayat-maya pinag-iinitan nating student activists sa mga universidad, mga academicians, mga intelektual, kahit mga fans ng progresibong banda tulad ng YouTube.
I would
So
say,
what kind of materials, good sponsor?
I would say, Mr. President, that's a matter of defense. No? Kasi kung may papakita naman niya na hindi, itong mga materials na ito, gusto ko rin mag-aral to counter terrorism or sa ibang kadahilanan, it's a matter of defense when it comes to that, Mr. President.
Fair enough, good sponsor, Mr. President, that it is a matter of defense. And I wish, in fact, the good sponsor would have been willing to extend this principle that it is a matter of defense in the case of any and all documents. But I suppose that we will have to agree to disagree on that.
Yeah,
Siguro,
we're
yes,
always
Mr.
bound by
Good
the intent
Sponsor.
of the person, Mr. President.
And siguro, Mr. President, just to express at this point in time of my interpellation of the good sponsor, dahil ito siguro yung thread weaving through all my questions. Ito yung thought behind all my questions. We need to craft laws assuming the most despotic of implementors. Dahil hindi po natin alam kung sino-sino ang mamumuno magpapatupad ng ating mga batas. We need to craft laws assuming not the most benign of leaders, not the most enlightened sa mga policymakers at law enforcers, not the most benign of leaders. We need to assume the most despotic of implementors. Kaya yung medyo matinding degree of caution at voice ko sa pagtatanong ng mga tanong na ito. To continue, Mr. President, and related dun sa naunang pinag-usapan namin ng good sponsor, Section 8. Section 8 penalizes, and I quote, any person who distributes or otherwise makes a message available to the public with the intent to incite another by any means, directly or indirectly, to commit a terrorist act where such conduct causes a danger of such acts being actually committed. So, medyo mahaba po, Mr. President. So,
Yes.
una pong tanong ko sa good sponsor, how do you make a message available to the public with the intent to incite another by any means, directly or indirectly, to commit a terrorist act? And let us, Mr. President, note the word indirectly. Pwede ba nating kasuhan ang U2 para sa protest songs nila? O para mas lokal, pwede ba nating i-charge ang Buklod o si Bamboo for inciting us na baliktarin ang Tatsulok?
Pag sinabi nating inciting, directed against the general public, ito yung pwedeng mag-lead do sa pag-commit ng terrorist acts, ano? Pero wala namang call to commit violence or to commit terrorist activities or terrorist acts, then hindi naman po siguro pwede masaklaw nitong batas.
Mabuti po,
Kung maliwanag
Mr.
naman na nagtatawag
President.
na tayo'y magpasabog o kaya pumatay sa pamamagitan ng sagasaan ng 6x6 truck tulad nangyari sa Nice, France, nang walang ibang intent kung hindi magsaw ng terror, papasok po yun dito.
Yun po, Mr. President, good sponsor, ay mga halimbawa ng mga directly inciting another to commit a terrorist act. Nagiging mas mahirap po, mas subject to interpretation, at sa ilalim nga nung sinabi kong posibleng most despotic of implementors, mas magiging problematic, posible, yung paggamit ng salitang indirectly. At the proper time, Mr. President, good sponsor, I will propose and would like to seek the opinion of the good sponsor at this point in time if he would accept an amendment removing the word indirectly.
We can talk about that, Mr. President.
Again, fair enough. Thank you for that possibility, good sponsor, Mr. President. Kasi, and further to this provision, how do you determine when the conduct causes a danger of such acts actually being committed? How do you measure danger? Paano po sinusukat yung panganib? Lalo na po kung indirectly inciting na sinasabi.
I'm sorry, Mr. President, I didn't
Yes,
quite hear
no problem, good sponsor. Paano po natin susukatin yung panganib? How do we measure danger? How do we determine when the conduct, lalo na kung indirect conduct, actually causes a danger of such acts being committed?
Well, it redounds to yung violence that will be created. Babalik na naman tayo doon sa intent, saka yung purpose ng pag-i-incite to commit terrorist acts, Mr. President.
So again, just to reiterate at this point in time, good sponsor, Mr. President, na ipapursue ko sa good sponsor yung sinabi nilang pwede naming pag-usapan yung posibleng pag-delete ng salitang indirectly because it would tend to create situations na ma-interpret at ma-apply itong Section 8
We'll be
excessively.
guided by the existing jurisprudence in this regard. And there are many, Mr. President. So,
Thank you.
yung Chavez versus Raul Gonzalez, marami po ito, pwede natin gawing reference at the proper time.
Yes, good sponsor, at the proper time. Salamat po. I'd like to go now, Mr. President, to the provisions on proscription. So, Section 21 amends Section 24 of the Human Security Act and states that any group of persons, organizations, or associations that commits any of the acts defined and penalized under the provisions of this Act or exists for the purpose of engaging in terrorist acts shall, upon application of the DOJ before a competent regional trial court, with due notice and opportunity to be heard, given to the group of persons, organizations, or association, be declared as a terrorist, an outlawed group of persons, organizations, or association by the RTC. In the next section, so Section 22, the court is required within 72 hours of filing of the application to issue a preliminary order of proscription. The respondent has the right to be heard and to show why the order of proscription should be set aside, and the court is required to schedule a hearing within a 6-month period from the filing of the verified application to determine whether the order of prosecution should be made permanent, set aside, modified, or lifted. Now, good sponsor, am I understanding it correctly that while the RTC must act on the urgent prayer within 72 hours, 3 araw lamang, it is given the leisurely period of 6 months within which to schedule a hearing to give the proscribed group or organization its day in court? Sa makatuwid, within this 6-month period, the proposed amendments give the state and its agents a free hand to perhaps wiretap, conduct surveillance, arrest, and detain any of its members without a warrant, examine bank records and accounts, freeze and seize properties, etc. And this all legally possible even before the organization or any of its members is given a chance to be heard. Kasi 3 araw ma-aksyonan, pero 6 na buwan bago pwedeng dinigin yung kabilang panig. Is my understanding of the proposed amendments what was intended, good sponsor?
Hindi po ganon, Mr. President. Yung order of prescription, ginawa nating time-bound because of the experience in the case of the Abu Sayyaf. It took, I think, 11 or 12 years before the court rendered a decision to proscribe Abu Sayyaf as a terrorist organization. In the meantime, so many kidnappings were committed in Basilan, in Tawi-Tawi, in Sulu, So, kaya po natin naisip na gawing time-bound yung gawain ng korte para mag-render ng decision to prescribe or not. But in the meantime, we are also giving them the authority to issue a temporary order of prescription. I think within 72 hours. That is correct. Thank you, Mr. President.
Yes, Mr. President, good sponsor. So tama po yung pagkaintindi ko. Sa loob ng 3 araw, kailangan aksyonan kahit through a preliminary order of prescription. Pero yung pinroscribe kahit preliminarily, sa loob pa ng 6 na buwan, pwedeng mag-set ng date at time yung korte para sa summary hearing. Hindi naman po siguro lahat ng posibleng temporarily proscribe o preliminarily proscribe ng mga organisasyon ay kasintindi ng Abu Sayyaf. What about groups who may later be proven na maling pinroscribe bilang terrorist or outlawed organization? Sa loob ng 6 na buwan, wala silang day in court, samantalang yung action which was taken against them ay na-actionan within just 3 days. Paano po yung proportion doon, good
Mr.
sponsor?
President,
Mr.
it doesn't
President.
necessarily mean that every time a petition is filed for prescription, that the court will issue a temporary order of prescription. Pwedeng outright denied yung temporary order of prescription. And we're giving the court, under this proposed measure, 6 months within which they should make the prescription order final, or it could also be dismissed at any time within the 6-month period.
Opo, Mr. President, good sponsor. Pero posibleng ma-preliminarily proscribe within 3 days.
Pwede po.
And what if nga po, pagkatapos ng pagdinig nitong kaso, mapatunayan na mali pa lang na proscribe, hindi pala siya terrorist organization, hindi siya dapat na outlaw, but it had to wait, its members had to wait 6 months to present their side and to be for the consideration of the court. So the court doesn't have to do it. The court doesn't have to act on the request for a preliminary order of prescription, but it can. It may. So paano po yung balanse doon, Mr. President?
Yung temporary order of prescription, hindi po ito arbitrary. Kailangan po merong ma-establish yung korte, yung RTC, ng probable cause. In the same manner, when a respondent, a suspect, is brought before a prosecutor under inquest proceedings, kailangan mag-determine yung, unless mag-waive ng preliminary investigation, yung respondent, yung suspect, yung prosecutor is mandated to establish probable cause or to outright dismiss the case or release the respondent in the meantime that further investigation is being conducted by law enforcement. So hindi naman po ganun ka-harsh na basta't nag-file ng petition for prescription, agad-agad pwede na agad na paghuhulihin at arbitrarily the court can just issue the temporary order prescription. Instead, the court must first determine if there's probable cause before issuing such temporary order of prescription. So meron pong due process ito.
Thank you, Mr. President, good sponsor. Totoo nga, dapat may due process sa pag-implementa ng anumang batas. Pero gaya ng nasabi ko po kanina, if we assume na posibleng sa anumang panahon magkaroon ng despotic implementor, hindi laging benign leader ang magpapatupad. Hindi laging itataguyod yung due
Mr. President,
process.
let me correct the impression that yung judiciary natin is independent of the executive branch. And if we question the wisdom of the court, then we're questioning the integrity of the court, of the judiciary. Let us assume that the courts, the RTC judges, are competent enough to determine if there is or there is no probable cause before they will issue a temporary order of prescription.
Certainly, Mr. President, I am presuming the independence and competence competence of our judiciary. At kung mapapansin po ninyo, hindi ko kasing itinatanong yung 72-hour period, yung 3-day period. Ang mas ko po tinatanong talaga ay yung parang disproportionately napakahabang 6-month period within which time pwede namang dinigin yung posibleng preliminarily pinroscribe. Dahil kapag ka ang sitwasyon ay nasa ilalim ng isang despotic implementer, and I'm not referring to the judiciary here, good sponsor, Mr. President, yun na nga, paano na po yung sitwasyon nung na-proscribe tapos posibleng maghihintay ng kalahating taon
Ganito
bago
po yung
siya
analogy. A
madinigdig?
better
Yun lang
analogy
po,
is
Mr.
is
President.
a common criminal case. Ano? A respondent or an accused is arrested. And then the law enforcement is mandated to deliver that person before a prosecutor within a reglementary period. Say, in the case of capital offenses, 36 hours. Ano? Pagdating sa piskal, pag may probable cause, ipapal yung information. And it will take a while before the court can determine guilt or acquittal nung suspect. So ganun din po yung takbo ng pangyayari rito. Before the court could issue a temporary order of prescription within 72 hours, kailangan ma-establish clearly na mayroong probable cause. And meron 6 months yung judge to issue a final prescription order. If there is no sufficient evidence to sustain or to support a final prescription order, then i-dismiss din ng court yun. But as you said, as we have discussed earlier, tama po yun. Within 3 days, nag-issue ng temporary order of prescription, pero ang safeguard naman doon, kailangan maka-establish muna ng probable cause, yung RTC. Remember, this is a judicial determination of probable cause, even higher than the ordinary probable cause established by a prosecutor.
Yes, Mr. President. But of course, di tulad ng mga ordinaryong criminal case, itong prescription sa usapin ng terrorism, prescription is for entire groups. So it would allow the state a free hand, yun na nga po, to surveil or even to wiretap, etc., all its members. So perhaps at the proper time, Mr. President, good sponsor, I could propose some proposed amendments for the consideration of the good sponsor, with emphasis on that 6-month period being so much longer than the 72 hours period. Thank you, Mr. President. One amendment, so I'm still here in section 22, one amendment is to include groups of persons and not just organizations and associations. So, could I test this with the good sponsor? Any member of such a proscribed group of persons can be made subject of warrantless arrest and detention, seizure and forfeiture of property, etc., even without committing the specific acts that cause death or destruction or other circumstances defining an act of terror.
Before you establish that you're a member. Sorry, Mr. President.
Yes, Mr. President. I'd like to clarify with the good sponsor, if my understanding is correct, na any member of a proscribed group of persons can be made subject of warrantless arrest and detention, seizure and forfeiture of property, etc., even without committing the specific acts that cause death or destruction.
That is correct. As long as it is clearly established that such person is a member of that proscribed terrorist organization.
And since these are individuals, good sponsor, Mr. President, can this include conjugal or family assets or only assets held by the terrorist groups? Because as the proposed amendments are written, they don't seem to distinguish between and among such classes of property.
Well, I would like to assume that pagka-conjugal property and one of the spouses is a member, established member of that proscribed terrorist organization, then subject sa forfeiture yung, kasi co-owner siya nung yung properties na yun, yung assets, Mr. President.
Thank you, Mr. President. Now, ito na itanong din po ni Minority Leader, kasama ng good sponsor. There are organizations that existed for the purpose of committing what could arguably in some other setting could arguably be defined under this bill as acts of terror, such as the Reform the Armed Forces Movement or even the Magdalo Group. However, it appears they no longer do so, since existing or being organized for engaging in terrorist acts can be interpreted as a permanent characteristic of such groups. Could they be made the subject of this proscription order?
Which one, Mr. President?
Earlier, the good sponsor discussed with the minority leader the RAM or the Reform the Armed Forces Movement, or even in an earlier
Iba po yung
administration,
intent, kasi
tinuturing na
yung
terrorista
Reform the
yung
Armed Forces
Magdalo
Movement,
Group.
ang intent nila to overthrow, and it is an act, a criminal act called coup d'etat. So iba po yan. Yeah. So we'll just go back to the definition of a terrorist act, Mr. President.
And hindi rin naman po na-contemplate ng good sponsor na ang isang grupo tulad ng Magdalo Group ay masama sa definisyon ng terrorist group sa bill po na ito.
Ang jurisprudence naman po dito yung Lagman versus Medialdea. May mga existing naman pong Supreme Court ruling na pwede natin gawing reference, Mr. President.
Thank you, good sponsor, Mr. President. Now, what is the standard of evidence that will be used to prove membership? Considering that many such organizations, di naman po sila exactly nagme-maintain ng roster of members, di naman sila nagme-maintain ng records tulad ng ganitong membership roll. The danger of a too lax standard of evidence is that we are giving, at ito nga po yung sabi ko, thread winding through all my questions, good sponsor, about possibly the most despotic of implementors. We're giving future authoritarian regimes carte blanche to arrest or detain anyone it can link to a terrorist organization, no matter how tenuous the connection. So ano pong standard of evidence ang gagamitin
We'll always
po?
be guided by the rule of evidence, Mr. President. Kung hindi naman ma-establish clearly na miyembro siya ng proscribed terrorist organization, he would not be subject to arrest. Mr. President, I notice every time you mention the word despotic, you always look beyond me. Ano pala siya?
I'm waving to my Mr.
always looking at your
Mr.
classmate.
President, good sponsor. Yes. Thank you, Mr. President. Napag-usapan natin ang korte kanina, good sponsor, Mr. President. Now, what is the rationale for letting the RTC rule on applications for proscription? Bakit hindi po yung Supreme Court o yung Court of Appeals? Considering that the Court of Appeals is the one with jurisdiction to authorize wiretapping and surveillance activities. And related po itong tanong na ito, good sponsor, sa usapin ng Freedom of Association at yung kabuang Bill of Rights natin. So bakit hindi po yung SC na lang or yung CA?
Unang-una po yung accessibility. Pangalawa, under the existing law which is RA 9732, RTC talaga yung nag-grant ng petition for prescription.
Would at the proper time, would the good sponsor considering laying the responsibility for proscribing on a higher level of the judiciary than the RTC?
Baka lalo magtagal, Mr. President. Unlike yung sa judicial authorization to wiretap, we're amenable to, in fact, we have already included in the committee report to elevate it to the level of the Court of Appeals, as suggested by the distinguished minority leader.
Thank you, Mr. President. Lastly, on this on these sections, no, sections 20 and 21, what is the venue for the application? The law doesn't even specify the venue. So technically, can the application be filed with any RTC in the country? I believe this has the potential to be abused.
Magde-designate po yung Supreme Court ng special courts for the purpose.
So the Supreme Court, good sponsor, will designate which RTCs may receive
Special
such
courts.
Special courts
For this purpose.
at the level of the RTC.
Parang mga heinous crime courts na nag-designate yung Supreme Court. In this particular case, the Supreme Court will designate special courts to hear proscription petitions
I see, Mr. President.
or anti-terror on anti-terrorism cases.
Thank you, Mr. President. I'd like to proceed now to Section 23 of the bill, which amends Section 27 and increases the period of detention from 3 days to 14. What is the rationale, good sponsor, Mr. President, for increasing the period of detention from 3 to 14 days? So half week to 2 weeks. In the worst scenarios, so is it so that subjects might possibly be subjected to 14 days of enhanced investigation or interrogation until they crack?
Mr. President, in his co-sponsorship speech, Senator Ronald De La Rosa shared with the members of this body his first-hand experience in Davao City. And the 36-hour reglementary period is not enough to build up a case against the suspected terrorist. And with your permission, let us hear directly from Senator De La Rosa what he experienced. And it created more damage when he was not able to file or make the inquest proceedings on the arrested suspects.
Thank you, my co-sponsor and Mr. President. Based on my personal experience, if really we are, indeed, the spirit of this bill is to secure the state and protect our people from terrorism by giving more teeth to our law enforcement in its anti-terror campaign, then I think we should extend the reglementary period from 36, the maximum of 36 hours to what is being penned in this bill. Because per my experience, the ISIS terrorist Muhammad Risa, which I presented during my co-sponsorship speech, I was able to arrest him in Davao City, but I had to release him after before 36 hours because I don't have enough evidence to hold him further beyond 36 hours. But I was fully convinced, the intelligence community was fully convinced, and they were forcing me, they were pleading before me not to release this guy because he was very dangerous. But I told them I cannot do otherwise. I cannot break the law. So I had to release him. But months later, Mr. President, the intelligence community showed me the video from YouTube, 3 of them, including Muhammad Riza. What a coincidence. Muhammad Riza.
Ibang spelling po.
Muhammad Riza was shown in the YouTube holding the head of the victim, European victims, and slashing the throat of the victim. So from being a local black flag terrorist here in the Philippines, in Lanao del Sur, he traveled to Al-Raqqa, Iraq, and he became an ISIS member. So he was able to slash a lot more throats from the victims, ISIS victims in Iraq and Syria. So if there was a law allowing me to hold him further beyond 36 hours, then many more lives could have been saved.
The current Human Security Act, Mr. President, already provides not just 36 hours, 72 hours. Doble po, 3 days. Ang tinatanong ko lang po ay, hindi ba sapat na yung 3 araw? Doble sa panahon na mayroon. Kailangan pa ba talagang idagdag hanggang 2 linggo?
Yeah.
And in fact, Mr. President, shouldn't the case be built up before arrest? Diba? Nung pong naaresto sa wakas yung Mohamed Reza, and definitely, persons like him should be arrested and subject to our laws. Hindi po ba bago pa inaresto siya, hindi po ba nabigyan ng ebidensya ang good gentleman from Davao ng intelligence community. So ano po yung evidence na mayroon that prompted the good gentleman to make the arrest in the first place? It must have been substantive.
For
enough.
the information of the good lady from Panay, ibang-iba po yung intelligence report from investigative reports. Intelligence reports has no evidentiary value, but they were classified as A1, meaning coming from the direct source and from first-hand information. So, iba po yun. Alam natin na yan talaga, but legally, it cannot stand in court. So, yan po ang dilema ngayon ng law enforcers. So, mabalik lang ako sa sinabi mo na sinabi ng ating interpolator, the good gentle woman from Panay, that instead of using the 72 hours as provided by the Human Security Act, the law enforcers are more inclined to use the 36 hours provided by the ordinary laws other than the Human Security Act, because we find more convenience in using the
Penal Code.
other laws
Penal Code.
other than the Human Security Law, because the Human Security Act is we find it very anti-police. Instead of giving more to the police, it is giving more fear to the police, because
Because of the
provision,
500 peso per day.
500 pesos per day,
500,000 peso per day fine.
100,000. Yes, sir.
So instead of filing cases for violation of the Human Security Act, the police would instead file ordinary violations of the revised penal code.
I understand,
to avoid
good sponsor.
the sabihin natin sword of Damocles, pagbabayaran sila ng 500,000 pesos per day once the suspected terrorist is acquitted. And on top of what Senator De La Rosa has shared with us, during the committee hearing, Mr. President, the members of the law enforcement agencies shared with us yung kanilang experience na kulang talaga yung 3 days. And they need more or less 14 days. And that's the reason why we incorporated in this measure yung reglementary period na 14 days. Look, tayo nga, we're just trying to be at par with other ASEAN neighbors, or Asian countries. Sri Lanka, 14 days. Australia, 14 days. Bangladesh, 15 days. Indonesia, 21 days. Ito yung reglementary periods. Pakistan, 30 days. Malaysia, 59 days. Singapore, 730 days. Tapos tayo, fix yung non-extendable yung 14 days. Other countries, other jurisdictions, yung Thailand, pwede pa sila mag-extend ng another 30 days. Yung Indonesia, extendable hanggang 120 days. Yung Malaysia, extendable hanggang 2 taon. And yung Maldives, extendable to an indefinite period. Singapore, indefinite period. Mabait po tayo, Mr. President. Kasi alam ko po na andyan kayo, kaya sabi ko 14 days, tama na.
Thank you,
Huwag na
good
natin
sponsor. I understand ganito po, Mr. President, ang trend sa iba't karamihan ng mga bansa sa region natin. And mas gusto ko pa nga na hindi sa manatiling mabait tayo, hindi mabait, pero
We value
patuloy-
human rights, Mr. President.
Exactly,
That's what I
good sponsor.
meant by
Yes.
saying mabait tayo.
Exactly, Mr. President. Good sponsor. Mas gusto ko po sanang manatili tayong kahit nagmumukhang odd man out, pero manatiling pilit na nagtataguyod nung mahabang track record ng ating bansa, struggling to uphold human rights and civil liberties, even under very challenging circumstances tulad nitong global threat nga ng terrorism, na humanap ng mga creative pero effective na paraan. I was even surprised, good sponsor, dun sa sinabi ng good gentleman from Davao na walang evidentiary value bilang investigation report yung intelligence report, because I know even as a civilian at bilang amista ng good gentleman from Davao, how hard, and the good sponsor knows this even more as a former chief PNP, how hard our police and military intelligence units work to gather, yung sinabi nga ng good gentleman from Davao, A1, intelligence information, which will enable our law enforcement officers to arrest these suspected terrorists or these terrorists. Kaya ako itinanong na hindi ba yung pag-aresto dun kay Mohamed Reza was actually backed up by solid evidence that could stand in court in the prosecution
bottom line
of the
here,
case,
Mr. President, is had Senator De La Rosa or Colonel De La Rosa at the time been accorded this particular provision extending the reglementary period for terrorists, no? Sana nasave natin yung inislas na leeg do sa Iraq, no? And on top of that, Mr. President, let me just inform you that there are safeguards that are put in place to prevent abuses under this particular provision. Number one, the law enforcer taking custody shall notify in writing the judge nearest the place of arrest of the following facts, no? Time, date, manner of arrest, location or locations of the detained suspects, physical and mental condition of the detained suspects. These are the additional safeguards na naisip naming ilagay para mabawasan yung or mawala yung abuses, possible abuses ng law enforcement agents, Mr. President. So hindi pwede yung itago-tago because they'll be answerable. And
Thank you, Mr.
they're also mandated to furnish with a written notice yung Anti-Terrorism Council, Mr. President. Ito yung mga safeguards.
Thank you, Mr. President. Of course, we also believe that we have to consider the rationale behind the original provision in the HSA, which is to prevent or frustrate an imminent attack. Because if an attack is already being carried out, then isn't it correct to say that not only can our security forces arrest the perpetrators in flagrante delicto, but they can also use deadly force to preserve public order or save lives?
Well, we should not wait for the destruction or the killing to happen before we conduct the arrest, Mr. President. We want to be proactive because malalakas na po yung mga anti-terrorism laws in other jurisdictions. And if we are left behind, we're opening up our country to be a safe haven for these terrorists. Ito pa po, no, Section 20, yung penalty for failure to deliver suspect to the proper judicial authority, meron po tayong provision na pwede sila makulong. Of course, it's already provided for under existing laws, yung tinatawag na arbitrary detention. Pero in-emphasize pa rin po natin yun.
Salamat po, good sponsor. At sa totoo lang po, itong pinag-uusapan nating longer period of detention na sinasabi ay global trend at nakikita natin sa ating rehiyon, regional trend nga, ay ginagamit laban sa mga estudyante, mga pro-democracy activists, pati human rights lawyers, na lahat po ay hindi mga terorista. And there's no evidence that this longer period of detention, no evidence that it contributes meaningfully against terrorism. Ito po
No, on the
mula
other hand,
po sa Amnesty
let's
International.
look at it from another perspective, Mr. President. No? Ito mga countries that they're adequately equipped. Tayo po hindi masyado. And yung existence ng batas na umiiral sa kanila that provides for a longer reglementary period could be contributory kung bakit kakaunti marahil yung nangyayaring mga terroristic activities in their areas. So sa atin, nagiging laboratory, nagiging training ground, just like Marwan and the other terrorists, yung sa Marawi. Kaya po nangyayari kasi mas magaang sila sa Pilipinas because of our weak laws on terrorism.
Rather, good sponsor, Mr. President, I think it would be arguable na dun sa mga bansa na mas may mahahabang reglementary period, lalo na yung mga mauunlad na bansa sa kanila, posibleng humuhupa ang terorismo because they are applying themselves to addressing the root causes of terrorism in a balanced way, kasama ng kasama ng effective law enforcement. So hindi heavily lamang sa law enforcement.
effective
may
laws,
kasama
Mr.
po.
President.
And effective laws, which I know
Which we
on the
don't have
floor we
right
are
now.
all seeking to, which is the argument of the good sponsor that we do not have right now. And at the proper time, I will propose some possible amendments to achieve that objective of enabling us to, as part of the community of nations, address the threat of terrorism while still unequivocally upholding our commitments to human rights and civil liberties. And Mr. President, further, if our security forces are still in the process of investigating a terrorist conspiracy, can't they build their case using the mechanisms already provided, for example, in the Terrorism Financing Prevention and Suppression Act? Secondly, the surveillance order provision in the current HSA, or applying for a good old-fashioned search warrant under the rules of court. A good sponsor.
We're trying to improve or enhance the Human Security Act by way of amending it, and including all these provisions, Mr. President. Because right now, there's only one conviction. Imagine when did we pass the Human Security Act? 2007. We are now 2020 na tayo. There's only one conviction so far. And one difficulty which we suggested that we delete, yung predicate crimes. Ito yung one of the handicaps eh. We have to prove first the predicate crimes before we can even proceed to prosecute the terrorist for violating the Human Security Act. That's why we deemed it necessary to just delete the predicate crimes, Mr. President.
I see, Mr. President. If the state needs 14 days with a suspect to get anything useful from him or her, hindi po ba fishing expedition na iyon?
No, definitely no. Yun nga po sa aming committee hearings, ito yung common experience ng mga law enforcement agencies present. Sabi nila, kulang na kulang talaga yung 3 days. Kaya nga sila humingi. Ang hiningi pa po nila 90 days na hindi nga ako pumayag dahil naalala ko kayo.
Salamat pong muli, Mr. President. I'll count on that kapag nagpo-propose po ng mga amendments. Last follow-up question po, good sponsor, dun sa pinag-usapan natin kaninang ano ba ang mala prohibita. Marami po kasi sa naging pag-uusap natin, ang naging sagot ay, let's always look at the intent. So, ano nga po ba yung mala prohibita? Ano po ba yung mga offenses sa ilalim ng batas na ito na hindi kailangan yung intent? Ano yung mala prohibita? Ano naman yung mga kailangan ng intent? Kasi dun po sa pinag-usapan natin kaninang possession of documents, sabi po, mala prohibita siya.
Yung intent po is a indispensable element yun eh. Kailangan establish natin yung intent is really to commit a terrorist act, Mr. President. We cannot deviate from that.
Pero sabi po ninyo kanina, good sponsor, yung possession of documents likely to facilitate a terrorist act ay mala prohibita. So, hindi
Kasi
kailangan
po
yung
may intent siya eh. Hintay pa ba natin na may sagawa niya yung kanyang karumal-dumal na yung kanyang terrorist activities?
Perhaps a good sponsor, Mr. President, in closing my interpellation and thanking the good sponsor, ilan po sa mga punto na ito na hindi po tayo sang-ayon sa posisyon ay subukan kong balikan at the proper time sa period of amendments para din pong mas gawing malinaw ang mga probisyon ng isang napaka-importanting panukala which if interpreted and implemented excessively or because of lack of clarity could actually do more harm than good. At isa na pong isang susubukan kong linawin na itong tungkol sa mga punto dito na may kinalaman sa mala prohibita which does not require intent. So
Rest assured, Mr. President,
Yes, Mr.
that at the proper time, I'm with you in really further strengthening, especially the safeguards, to protect human rights. But not to the point na isasacrifice naman natin yung safety ng karamihan ng ating mga kababayan, Mr. President.
Let's search for that balance, Mr. President, with the help of the good sponsor. Probably a difficult balance, pero tingin ko necessary talaga kung saan magtatagpo yung human rights at yung public safety, or kung saan magtatagpo yung public safety and human rights. So by way of ending, gusto ko lang pong ulitin ito. We do craft laws assuming the possible worst in our future implementors. Democracy demands a healthy distrust of power. At alam po natin yan bilang legislature na maya't maya nagche-check and balance sa dalawa pang branches of government. So let's continue to deliberate on this measure, but let's also keep these tenets in mind. At the very least, let's make our laws as clear as possible and remove all possible ambiguity. Maraming pong salamat, good sponsor. Salamat po, Mr. President.
Thank you very much, Mr. President.
Mr. President,
Yes, Majority Leader.
at this juncture, may we recognize, but before that, I think the gentleman from Olongapo would like to
I
make
do
a...
not recognize Senator Subiri here. Has he shrunk in size, or is there a permission from the chair that we now have a new majority floor leader? Your Honor?
He's the Assistant Majority Leader, so if the Majority Leader steps out.
So he
can
just
take it.
steps in and
I'm being questioned,
He
Mr.
can,
President.
he can step in
Unfortunately,
anytime.
by my fellow.
because we've been arguing who's going to be next, and that's why I'm also giving him a hard time. Thank you, Mr. President.
Mr. President, this juncture, may we recognize, to continue the interpellation, may we recognize Senator Bong Revilla to ask
All right.
questions to the distinguished
Senator-
gentleman from Cavite, Senator Lacson.
Senator Bong Revilla for the continuing interpellations.
Thank you, Mr. President. May the gentleman from Cavite, my kababayan, yield to some clarificatory questions.
Willingly to my kababayan from Bacoor, Mr. President, Bacoor City.
Thank you, thank you. Mr. President, the 2019 Global Terrorism Index, GTI, ranked the Philippines ninth among the 163 countries in the world. Ayon po sa report na ito, kahit na bumaba sa ating bansa ang terror-related deaths at terror-related incidents, ang the Philippines remains the only Southeast Asian country to be included in the top 10 list most impacted by terrorism. Nakakabahala po ang report na ito, Mr. President. Kaya naman napapanahon ang panukala ng aking kababayan na si Senator Lacson na amendahan ang Human Security Act. At ito po ay aking sinusuportahan, Ginoong Pangulo. Meron lamang po kung ilang katanungan. Now, Mr. President, under the Human Security Act of 2007, the commission of acts of terrorism is anchored on the commission of certain predicate crimes like piracy, kidnapping, rebellion, etc. Pero dito po sa proposed Anti-Terrorism Act, particularly Section 4, I noticed that the predicate crimes have been removed. May I know the reason for this, Mr. President, by removing the predicate crimes? Have we not made the definition of terrorism or terrorist act overbroad, thereby making prosecution of the crime difficult? O mas pinadali natin ang pag-prosecute dahil sa bagong definition, Mr. President?
Thank you for that question, Mr. President. Based on our experience, after the Human Security Act was enacted or was passed in 2007, there's only one conviction, and one of the identified handicaps is the presence of predicate crimes, because and we have had only just one conviction since that time, because we have to prove first the existence of the predicate crime or crimes identified before we can even proceed to prosecute under the Human Security Act. So we deemed it wise to just remove the predicate crimes.
So, mas madali na po ang prosecution, Mr. President.
Hindi pa natin alam po yun dahil hindi pa na
Hindi pa
ipapasa
natin
itong batas.
nasusubukan. So, sa inyo pong pananaw, mas mapapadali po.
Yun po talagang isang handicap kung bakit isa pa lamang yung nagiging conviction. At tinanong namin yung judge mismo na nag-convict, si Judge Felix Reyes ng Taguig. At sinabi niya, nahirapan talaga siya dahil kailangan i-prove niya muna yung predicate crime bago pa lang ma-approve yung violation ng Human Security Act.
Mr. President, the Philippine Human Security Act was enacted more than 10 years ago. Miyembro po ako ng 13th Congress nung naipasa ang batas na ito. Maaari po bang malaman kung meron na bang na-convict sa kasalukuyan nating batas laban sa terorismo?
Isa lang po, isa.
Isa po.
Ang na-proscribe na terrorist organization, iisa pa lang din, yung Abu Sayyaf.
Abu Sayyaf.
Kaya talaga napakahina po ng batas. Unang-una, natatakot po, nag-aalala yung ating law enforcement agencies na bakit pa tayo magpapile ng violation ng Human Security Act? Pag na-acquit yan, pagbabayarin tayo ng 500,000 pesos per day of detention.
Wow.
So ang ginagawa po nila, maski nahuli nila yung maliwanag na terorista like in Marawi City, ang pinapal nila multiple murder. Kung ano nung mga violation na lang ng revised penal code, kasi nga nangangamba sila, pagka nagkamali yung prosecution at na-acquit, saan sila kukuha ng pangmulta? Isipin nyo kung makulong ng 10 araw, yung 500,000 pesos a day, 5 milyon po yun na manggagaling sa bulsa ng law enforcement agents na humuli at nag-detain. Napakahirap po talagang gamitin bilang weapon against terrorism ang Human Security Act of 2007. Kaya kailangan po talagang i-amendahan
talaga. Ang susunod ko pong katanungan ay patungkol sa sections 21 at 22 ng Anti-Terrorism Act regarding proscription of terrorist organizations, association of, or group of persons. Naitanong na po ito kanina ni Senator Ontiveros tungkol sa proscription. Meron lang po kung ilang karagdagang tanong, Mr. President. Ang provision na ito para sa proscription ng terrorist organizations, associations, or group of persons ay hindi po bagong provision. Meron din pong ganitong provisions under the Human Security Act of 2007. Tama po ba?
Tama po yun.
What is new here is the issuance of a preliminary order of proscription under Section 22 of the proposed Anti-Terrorism Act. Is this correct, Mr. President?
Tama po yan.
May I know, Mr. President, the purpose why added this specific provision? What is the importance of the immediate issuance of a preliminary order of proscription?
Tulad po ng nasabi ko kanina, yung Abu Sayyaf group, na
Opo.
alam naman natin lahat na talagang a band of terrorists, it took, Basilan Court ba yun? It took the court, the RTC, to issue the order of proscription after 12 years. In the meantime, namamayagpag po yung Abu Sayyaf sa pagkikidnap, pagputol ng ulo, pagte-terrorize. So, naisipan po natin itong provision na ito na aside from making the order of proscription time-bound on the part of the RTC, yung 6 months, binigyan pa rin natin ng poder, ng kapangyarihan yung korte na mag-issue ng preliminary order of proscription na within 72 hours, pwede siya mag-issue ng preliminary order of proscription. That will be made permanent by way of a final order of proscription within 6 months kung meron sufficient ground to order the proscription.
Once the preliminary order of proscription has been issued, ano po bang epekto nito? May law enforcement or military personnel conduct surveillance on the preliminary proscribed terrorist organizations, associations, or group of persons?
Marami pong pwedeng magawa. Pwedeng i-freeze na yung assets, yung accounts. Pagkatapos pwede ring arestuhin yung mga established na mga miyembro ng terrorist organization na na-proscribe na or na-issuehan ng preliminary order of prescription. na pwede naman pong mabaliwala kung hindi mag-i-issue ng permanent within 6 months. Halimbawang after 1 month, nakita na kulang talaga yung basihan para ipagpatuloy yung temporary or preliminary order of prescription, pwedeng ilips yun.
Mr. President, ano po ang mangyayari kung pagkatapos ma-aresto ang mga suspects, pagkatapos mag-surveillance ng mga otoridad o pagkatapos ma-examine o mabuksan ng mga bank accounts, ay isa-set aside o ipawalang bisa ng korte ang preliminary order of proscriptions? Will our law enforcement or military personnel face charges from these organizations, associations, or groups? Ano po ba ang mangyayari sa mga nakalap na impormasyon, Mr. President?
Hindi naman pwede makasuhan na po yung ating law enforcement kasi valid naman yung grounds nila for arresting and mag-freeze ng mga accounts or assets ng mga persons.
Doon po sa mga information, Ginoong Pangulo, ano po ang mangyayari doon? Anong gagawin nila?
May confidentiality po yon, hindi pwedeng kung kanino ibibigay. Nasa provision po yon na talagang limitado lamang po ang makakaalam noong mga information na yan.
Okay. Under the said section, the order of proscription issued by the RTC is valid for 3 years, and thereafter the order shall be reviewed. May I know the procedure for the review, Mr. President? Will the court motu proprio review it, or the law enforcement or the military personnel has to file a petition?
Yeah, tama po yan. Within 3 years, pwedeng malip na yung prescription.
Paano po yung procedure ng review?
Ano po yan? RTC rin yung the normal course of due process, Mr. President, will apply. Yung filing, lahat. Kompleto po yan.
Okay. Mr. President, may I just go back to the GTI report I mentioned earlier. Under the report, GTI noted the New People's Army, NPA, as terror group responsible for over 36% of the terror-related deaths and 39% of the terror-related incidents recorded. Still, according to GTI, NPA is the Philippines' deadliest terror group, followed by the Bangsamoro Islamic Freedom Movement, or BIFM. Mr. President, meron po bang proscription case na isinampa laban sa NPA
Meron
o
pong
laban
pending
sa
na-
BIFM?
Meron pong pending na petition pero hindi pa po nakapag-decide yung RTC.
So wala pong...
Wala pa po. Hindi pa declared na terrorist organization ng CPP-NPA dito sa ating bansa.
Meron din po akong ilang katanungan tungkol sa Section 26. Mr. President, Section 26 of the proposed Anti-Terrorism Act of 2019 speaks of Anti-Terrorism Commission. Is this the same as the Anti-Terrorism Council under Section 41 of the proposed act, or different entity?
Yeah, meron. Pero tayo wala pa. Ano po yung nabala po ako nung
Is this-
aking kabalyer?
Is this the same Anti-Terrorism Council under Section 41 of the proposed act, or different entity?
Meron po mga additional members ng Anti-Terrorism Council. Yung Secretary ng DICT, Secretary ng DOST, DOTR, DOLE, DSWD, tsaka yung Presidential Advisor for Peace, Reunification and Unity, at tsaka yung Chief Minister ng BARM. Ginawa rin niya miyembro po ito ng Anti-Terrorism Council.
Okay, Mr. President, may I recommend the inclusion as member of the Anti-Terrorism Council, the Executive Director of AMLAC, considering the important role that they play in the counter-terrorism financing?
Yung Executive Director.
Mukhang hindi po yata sila nakasama.
Member po ang Department of Finance. At yun naman pong Anti-Money Laundering Council.
Pasok sa Department of
Opo.
Finance.
Kaya
Okay.
pwede rin pong siya mag-represent doon sa Secretary of Finance, doon sa anti-terrorism. So, pwede rin po ilagay natin doon sa batas para mas klaro?
Mr.
Well, at the
President?
proper
Is that
time,
okay?
if
At
you
proper time,
introduce the amendment, we
That's
will
right, hear the
consider, Mr.
amendment.
President.
Thank you, Mr. President. Again, I support yung ito pong panukalang batas ninyo, mga mahal na kababayan, and I support this measure. Mabuhay po kayo. Thank you, Mr. President.
Maraming salamat po.
The gentleman from Zambales, Senator Richard Gordon, is recognized.
Thank you very much, Mr. President. Will the good gentleman yield to just a few questions?
Willingly to the distinguished gentleman from Zambales
Mr. President.
and Cavite, of course.
Cavite, that's correct. Thank you. Mr. President, there are bound to be good Samaritans. Let's say in an encounter between terrorists or what have you, there will be good Samaritans who could probably be a doctor, could be a Red Cross volunteer who would provide first aid. Would that be considered material support?
No, Mr. President. Basta humanitarian aid under the auspices of the United Nations o kaya yung Philippine National Red Cross.
International Red Cross.
Maski po sa gyera, pwedeng tumulong yun sa kalaban.
Yes, that's correct.
Ganon din po dito.
Right.
Basta humanitarian aid, exempted po.
I am constrained to make sure that it is clarified because to the uninitiated, they might think that's support. So, will the gentleman be willing to accept an amendment later on during the period of
Of course,
amendment?
Mr. President.
Thank you very much. That having been clarified,
And thank you for that input because hindi namin nasama sa committee report and I'm glad that you mentioned that because we parang as an afterthought, naisip nga namin na yung trabaho ninyo sa Philippine National Red Cross, humanitarian aid, hindi dapat masaklaw nung pagbibigay ng material support.
opo. Pero yun ho, talaga by international convention yun.
Yes.
International Committee of the Red Cross, International Federation, or for that matter, the Philippine Red Cross covered yun. Pero ang sinasabi ko, halimbawa, and you already answered it, I just wanted to clarify it further, all the questions we're asking, it's like Senator Drilon and all the others here, is to make sure that when the court gets a case here, they can go back to the records para malinaw kung ano intention natin. Para malinaw na malinaw. So having said that, yung Good Samaritan na doktor or first aider, tinulungan yung terrorist to save his life or to alleviate his suffering, he is not covered that because that's a humanitarian act.
That is correct, Mr. President.
Yes, sir. Now, there will be occasions, for an example, where the Red Cross will go, and we do this, even to the NPA camps or even to the Abu Sayyaf. We've talked about that with them. I personally have done that. And we tell them, hey, you are bound also by international humanitarian law. And huwag nyo kaming guguluhin dahil magbibigay kami ng dugo. All combatants are involved in our franchise na dapat tulungan ang combatants whether legal or illegal or legitimate government or the rebels. Obviously, in this particular case, that will also not be considered as giving material support or comfort to the enemy.
I would like to reiterate, yes, Mr. President.
Thank you, Mr. President. I appreciate that very much. Now, I just want to have some questions clarified, especially on the matter of prescription. Prescription is a big word, not very common.
Yes.
And therefore, pagka prescription, para lang maliwanagan ng mga nakikinig sa atin, yung prescription is an application para ma-identify natin lahat yung mga terrorist organizations. Tama po ba yan?
Tama po yan.
Para sa ganon, pagka na-identify sila, pag hinuli sila, pwede silang ma-detain for a certain number of hours na hindi na mag-worry yung tao.
Tama po yan.
Yung tauhan natin, no? Of course, legitimately done, no? Legitimately done. So, the process is they apply for prescription which must be granted by the court or not granted by the court within 72 hours. Would that be correct, sir?
That is just the preliminary order of prescription.
That's
Yung
correct,
6
sir.
months, yun yung pong final. Yung
And the final, after 60 days, with hearing.
6 months.
Within 6 months.
With
sorry,
hearing,
within 6 months.
Yeah, due process, Mr.
The
President.
process. So, that is a very good proposition here because that means that we are really being careful in the matter of who to prescribe. that the government is a respecter of human rights, no?
Ang
Now,
ayaw lang po natin dito, you want to sawa. No?
That's
Kaya
correct.
nilagyan natin ng period na within 6 months, kailangan mag-decide na yung court whether to grant or not yung petition for prescription.
and thank you very much, sir. And having said that, let me now go into another aspect of it. There are such things as principal, accomplice, and accessory. Those who give material support, yun ang unang objective para malaman. Ngayon, pag nagbigay ka ng material support, how will we determine kung sino ang principal o kung sino ang accomplice? Because yung principal, obviously, indispensability ang kailangan. He cannot do it without the help of the principal supporter. Correct, sir? Is that
Correct, sir.
Now, the accomplice is kind of hard because material support yan eh. Could you give us some examples for the benefit of posterity when somebody becomes a principal and when somebody becomes an accomplice?
Pagka principal po, either by direct participation or
Yes.
by inducement.
That's correct.
Yun po yung principal. Co-conspirator ka, part ka ng conspiracy, principal ka.
And the common denominator will be indispensable yung ginagawa mo.
Indispensable.
Indispensable. Tama ho yan. Whether it's hindi magagawa kung hindi ka kasama.
Opo.
Now, yung accomplice po, pareho yun, nagbibigay ng material support. When does he become an accomplice? Because parang mahirap yung definition, nagagalaw ka lalayo ka sa principal kung tumutulong ka. When does tulong or helping become described as an accomplice?
Well, at any stage of the execution, pwede ka maging accomplice, Mr. President.
Halimbawa,
Even-
sir, may I make an example? If you mind. Supposing there are terrorist organizations and they're going to conduct bombing activities, no, or whatever, and everybody is assigned, ikaw tigadala ka ng bomba, ikaw tigasud ka ng bomba, those are principals. But supposing in the course of nadaanan ni isang tao, yung mga tao, kilala niya, pare, pwede ko bang hiramin niya sa sakya mo at ihatid mo ako doon sa lugar. And without his knowing it, or even on the way there, he gets to know it, and he wants to get out, he can no longer get out. What is he now? Is he a principal or an accomplice?
I think papasok po yun sa accomplice.
Accomplice.
Opo.
I'm just clarifying kasi because that's a very thin line eh. It's a very thin line. In other words, I am unwilling pero nandyan na, sinakay ko kayo, nabigay ko yung tulong, pero baka nga hindi pa rin accomplice dahil under duress eh. Di ba?
That's a matter of defense, Mr. President.
Yes, correct. Of course. So, ito, accomplish siya pag tinawag yung tricycle, halika, hindi mo ito, sama mo ko, pupunta ako doon. Ganun ba? Napasama siya. Accomplish.
Kung willingly at saka kasama siya doon sa alam niya yung intent at willingly sumama siya at nagatid, pwede siya makasuhan as an accomplice, Mr.
Nagatid siya
President.
pero ayaw niya, pero takot siya. Merong intimidation factor.
Depensa niya po yun. Kung tinututukan siya ng baril at kung hindi niya sasakay, papatayin siya.
Kahit hindi
under
tulungan ng baril,
duress.
pinakita lang yung baril, sumama ka.
Under duress na rin po yun.
Under
Mr.
duress na rin
President.
yan. So may lusot siya, yun ang depensa.
Depensa niya yun po.
Kasi I just want to be clear on yung sa accomplice. Basta, ang principal distinction is, sa principal talagang the crime could not be committed without you, which is basic in revised penal code. No? Sa accomplice ako na medyo nahihilo ng konti dahil this is a continuing process eh. Lalo na kung conspiracy yan, nasama ka, when you become an accomplice, parang mahirap maging hindi ako principal eh.
Kung nahirapan po kayo at abogado kayo, lalo mahirapan ako.
In other words, kung nagkakaalaman na mahirap hindi eh. Kasi you're adding, moral support.
Mr. President, it all depends on the appreciation of first the prosecutor and eventually the judge.
Yes. On
And,
whether,
again, it depends on how the prosecution and the defense will present their arguments, Mr. President.
yes. I'm glad that you took away the provision of 500,000 per day.
Nako, malungkot. Opo.
Di ba tinanggalan natin yan, di ba? Because talaga hindi makakagulo. Pero on the other hand, kailangan rin na ang ating ginawa dyan, nilagay natin yung definition ng prescription para there's a process para at least you're allowed how long now to detain him? Detain somebody? 15 days? Or 14 days?
14
days. Unextendable.
Non-extendable, Mr. President.
Non-extendable. So if you don't file the case within 14 days,
You have to release
you have to release without any fine,
without any penalty.
any
Mr.
sanctions,
President.
right? Any
Any
penalty,
sanction.
right? So, okay, I'm glad that that's clear. And this makes the military or the police more bold. Wala na yung cloud of threat na pwede kang ma-fine ng matagal. But how do we protect the citizen from gulang? Magulang yung enforcer. In other words, iba para mahabaan niya, gagawa siya ng paraan para may tago yung prisoner.
Mahirap po yun kasi may provision po tayo rito na kailangan informahan niya yung judge sa pinakamalapit na lugar kung saan nangyari yung arrest. Susulatan niya pa yung Anti-Terrorism Council na yung taong inaresto, pangalan ng tao, lahat ng circumstances nakasulat po doon at kailangan informahan niya.
Again,
Yung
this is a matter of defense. Ano po? If he says, wala akong hindi ako makapunta doon sa judge. Wala
Pero
akong
malinaw po
mautusan."
ang depensa dyan dahil may written notice sa ATC. Kung wala po maipakitang written notice, medyo malabo yung depensa nyo na
When does
in-inform
the
nyo.
written notice come in? On the first day he arrested him?
May,
Yung notice ba? Kailangan magbigay siya ng notice on the first day
sa
of his arrest?
Anti-Terrorism Council po.
So, first day.
Yes, upon arrest.
So, talaga
kailangan-
hindi siya makakagulang doon.
At saka yung judge, in the nearest location where the arrest was conducted, kailangan maimpormahan din.
Now,
At may mga penalty po yan pag hindi niya ginawa.
of course. Now, my next question would be, yung sinasabi nga natin kanina, hindi sila maka-arresto dahil natakot sila. Kaya ginagawa nila, revised penal code na lang. Di ba?
Opo.
So, eto ngayon, wala nang takot dyan. Now, the problem now is when the arresting personality, whether he be a policeman or a military or anybody charged with authority to arrest, ang problema ngayon dyan is how he would have to, I lost my point, how he prevents himself from being accused of being arbitrary and capricious. Because there's still room for arbitrariness and capriciousness and for abuse.
In the conduct of the arrest,
Correct,
Mr. President.
yes.
That is correct, Mr. President.
He would have to explain to the court that he did everything possible to make sure that he followed in the performance of duty. He was able to do that. He was able to do that. Would there be any requirement like that?
Well, hindi na po natin pinapalitan din yung provision sa citizen's arrest in this case. No? Kaya lang in-expand natin yung period. Ordinary crimes, hindi po pwede yung nasa planning stage ka, hindi mo naman ginawa, hindi ka naman nag-commit ng crime. Pero dahil yung mga tinatawag nating inchoate offense, hindi pa nangyayari, nasa simula pa lamang, pwede na nating arestuhin because we want to be proactive because this is a unique, this is a new phenomenon, Mr. President, which is global in nature, and we are trying to avoid for this phenomenon to become a new normal. Kaya gusto nating bigyan ng special treatment dito sa batas yung ngipin ng law enforcement agencies natin to really implement the law on terrorism.
This is a fact of reality nowadays that we are infested by possible terrorists who are bound to do ill will with impunity and they don't care. Now, let us put it this way now. Di ba, and I'm not necessarily agreeing with what I'm saying here, the penalty of life imprisonment or death might be too large and too big, so much so that it opens the avenue for bribery.
Of course, Mr. President.
So, how do we prevent that? And dapat, like you say, first day lang, alam na natin, nire-arresto niya. So, dapat, the commanding officer or whoever is in charge of this gentleman, the superintendent in charge, should be able to make sure that he's not doing this to intimidate others for bribery, di ba? For opening the groundwork. Kasi pagka masyadong malakas ang penalty, baka mangyari paging hanap buhay.
Mas malaki yung yung bribery. Kasi mas malaki penalty.
Oo nga, oo.
Tama po.
Yun ang isang concern. It's just I can see where you're headed here and I support it, but I'm just trying to find out ways to avoid that. No?
And it is important that we're discussing these things because it will be part of our record.
Correct.
When the time comes, we will have enough reference to go back to, Mr.
That's
President.
right, that's right. That's the whole object of the exercise, to make sure that there is sufficient discussion here so that when the courts ask, ano ba yung intention nila,
Yes.
malinaw. So really, the penalty of 500 of life imprisonment or death or life imprisonment, no, is severe because a terrorist nga will exact either to follow or not to follow because they're intimidated to do something that a government will be forced to do something because otherwise he will kill people or he will crash a plane or something like that, and that's why it has to be heavy.
By the way, Mr. President, yung 14-day reglementary period is not arbitrary or whimsical. There are grounds to be followed, no,
Yeah.
or to be complied with. It must be established. Yung before you can detain for 14 days, it must be established that one, the further detention of the person or persons is necessary to preserve evidence related to the Terrorist Act or complete the investigation. That's number one. Number two, the further detention of the person or persons is necessary to prevent the commission of another terrorist act. Number three, that the investigation is being conducted properly.
Yes.
So without these grounds, you cannot just whimsically, or the law enforcement agent or agents cannot just arbitrarily apply the 14-day reglementary period. May mga grounds pa po yan.
Thank you very much for that. Now, in the case of terrorism, there has been things like this is probably taken up in the first original act of the Security Act. No, there will be such things as torture, reduction, yung mga ganyan. Has that been taken into consideration in your
Opo,
hearings?
bawal po yun.
Bawal
That
mag-torture.
will be covered by another provision of the Revised Penal Code or any or Anti-Torture Act, yung mga naipasa natin batas, Mr. President.
And how does one prove kung wala naman testigo, kayo-kayo lang nahuli yan, and then na-torture siya, there were no marks, talo na siya. Wala siyang testigo.
Magaling po yung pulis pag gaganon.
Oo nga. May turo ba kay General De La Rosa? Biro lang, biro. Just being levity aside. So I'm just trying to figure a way out na hindi tayo basta-basta ma-accuse that we are being irresponsible here. That
Nandiyan po sa Section 29 ng
Okay,
ating
yes,
proposed measure. Penalty for threat, intimidation, coercion, or torture in the investigation and interrogation of a detained person.
yes, I'm aware of
Ano
that.
po yan? Abot ng from 12 years and 1 day hanggang 20 years of imprisonment ang aabutin ng ating law enforcement agents kapag nag-violate sila dito under Section 29.
But precisely for so much as we're trying to avoid to preempt terrorists, we're giving high penalties and we're going to prescription. The other side of the coin is to prevent and make sure that the law enforcement will be true to his oath, true to his code. And what are the things that we have done to make sure that he's not able to do so over and above the penalties that we're going to assign to him?
Mabuti po, nandito si Senator Risa. Meron pa pong concurrent jurisdiction ng Commission on Human Rights. Sinama po natin under Section 40.
Yes.
Dito. Para talaga ma-safeguard yung human rights ng detained suspects, Mr. President.
And they are supposed to inform them also
Yes, Mr.
on
President.
the first day.
Kasama ba human rights information? If you want to introduce amendment, then we can also include, because anyway,
Well, we don't-
we are informing the council, we're informing the judge. We might as well include the Human Rights Commission do sa pag-notify.
I'm just trying to ask these questions so that we can see that the playing field is level. Tagilid tayo dahil yung nagte-terrorize, walang qualms yan about killing. Walang qualms yan about crashing a plane. Pero on the other hand, tayo, we play by the rules. We have to tell the court the first day. We have to tell the human rights. Is there any way na, I think in the Human Security Act in the United States, ang ginagawa nila, dinadala nila sa Uzbekistan, dinadala nila sa ibang areas para hindi sila mako-cover niyan. Guantanamo, dinadala nila yan dyan. But dito, walang magdadala sa atin dyan, anuman lugar dyan, unless, and we don't have the resources to do that either. Would that be correct, sir?
Yes, Mr. President. Meron pang additional consequence, ano? Pagka nangyari yung cruel, inhuman, degrading treatment, talagang absolutely prohibited, mababaliwala lahat yung ebidensya.
Yun.
Magiging inadmissible, Mr.
Fruit of the
President.
poison tree.
Yes,
Lahat
Mr.
ng ginawa mo,
President.
because you did that, erased.
Erase
Deducted
lahat yung
lahat yan.
ebidensya mo, maski malakas.
Yes. And one more question that I hope I can remember right now, but on the matter of, well, it will come back to me later. I'm just so darn tired that we're not having had too much sleep, but maybe at some time, if the interpolations are
Ako
not
rin po,
finished,
Mr. President, medyo pagod na rin, so pwede tayo mag-break
That's
muna.
correct. We've been working since this morning.
That is correct,
And
Mr.
we've been
President.
doing good law, actually. So I would request that my interpolation be suspended, Your Honor. Anyway, Senator De Leon is going to ask. And with the permission of the good sponsor, I'd like to be able to ask, should it come back to me and ask that question? And then just a few questions, just to make sure that it will be all right. Thank you very much, Mr.
There's
President.
another bill under consideration. I'm excited to hear the interpellation of Senator Drilon kay Senator Tolentino, Mr. President.
Well, he is the new Manny Pacquiao. Thank you very much.
All right, Majority Leader.
Thank you, Mr. President. Our good distinguished colleague from Cavite was going to ask the sponsor for a few questions, but maybe we can take a break, Mr. President.
All right,
As requested by the
session is
sponsor.
suspended for a few Senate minutes. Session is resumed.
Mr. President, to continue the interpellation of on Senate Bill number 1083, with the permission, of course, of the sponsor. Okay po. Okay po kayo?
I understand that they would want to suspend consideration.
House suspend, so
So
Senator
that we can,
Tolentino will no longer ask?
We can
Monday.
proceed to the next item on the agenda. I think that is what the
May I ask for a 1-minute suspension again, once again, Mr. President?
session suspended.
So, sa'yo, Monday na. Okay po kayo sa kanya? Okay. Okay. Okay, Mr. President, ready to resume.
Session resumed.
I was a bit confused in the earlier. Mr. President, I move to suspend consideration of Senate Bill number 1083 for Monday.
Any objection? Hearing none, consideration of 1083 is hereby suspended.
Mr. President, I move to resume consideration on Senate Bill number 1211 or 1211 under Committee Report number 25.
Hearing no objection, consideration of 1211 under Committee Report 25 is in order.
May we recognize Senator Francis Tolentino to sponsor and to interpolate the distinguished minority floor leaders.
The sponsor of the measure, Senator Francis Tolentino, is recognized. And to interpolate, the minority leader, Senator Frank Relon.
Thank you, Mr. President. Will the gentleman sponsor yield a few questions?
Willingly, Mr. President, to the erudite minority leader, Mr. President.
Mr. President, there is an old adage which says, necessity is the mother of all inventions. Necessity is the mother of all inventions. It is because of the necessity to have a solution to our horrendous traffic problems in Metro Manila that the angkas issue is now in the forefront of our news. The effort to provide convenient transportation to our riding public, even if it's fraught with some danger, is being pushed because the necessity of looking for a solution. It is because of the adage, necessity is the mother of all inventions, that there is an effort to provide emergency powers to our Secretary of Transportation. It is in that aspect, Mr. President, that I see the effort of the good sponsor to pass this provision which seeks to amend Section 17 of the Local Government Code or Republic Act 7160. So, Mr. President, may I know what this provision seeks to address? We were going through the sponsorship speech, and it would appear that indeed it is the traffic issue which is being highlighted, and so this amendment is being proposed. Our first question is, what can be done by the LGU under the proposed amendment which they cannot do at present? In other words, are the LGUs prohibited under the local government code from engaging in the activity outlined in the proposed measure? That's the first question, sir.
Yes, Mr. President. The question really calls to my mind the relevance of the provisions of the local government code as applied to the current situation, which the good gentleman termed as a requirement for necessity. Mr. President, under the current local government code, our LGUs, while basically empowered to have their own measures to alleviate the traffic conditions, are more or less shackled by existing regulation or the non-existence of a legal mandate that would empower them, so to speak, Mr. President, to have their own traffic solutions. Principally, I refer to highly urbanized cities endeavoring to have their own rail-based transport systems within their jurisdictions. For instance, I mind the situation of Makati. They would want to have their own subway system, but the present governing law, specifically Republic Act 7718, the BOT law, and all other existing regulations would limit their capacity to enter into such projects without going through the rigorous, burdensome process of going to the NEDA, the ICC, and perhaps taking more years before a project is from conceptualization to operation is approved, Mr. President. And if I may add, Mr. President, since the enactment of the local government code, only one LGU was able to have its own project, but it's not related to transportation. It's a slaughterhouse rehabilitation of the municipality of Kalibo. Since the BOT, PPP regulations were enacted, Mr. President.
Mr. President, yes, so much was said in your sponsorship speech. But are we saying, for the record, Mr. President, we just want to understand this bill. When you say that the local governments are sought to be empowered to have their own measures, since they are today shackled in coming up with solutions, particularly on the transportation matter, is the gentleman saying that the purpose of the bill is to unshackle these restrictive, the local government units from these restrictive provisions and revise the present regulatory framework for transportation projects? In other words, so that's the question. We want to be clarified, because the reason for that, Mr. President, is the way we read the measure as worded, it is not obligatory. It is permissive. It is encouraging the local government units to go into transportation projects, and therefore to point out that they have this power to do so, because right now it would appear that only the city governments would have this power. So we're trying to understand what issue or what policy is being addressed. To be more specific, is the intention to remove what you call as the restrictions in the exercise of the power, the restrictions being the regulations and laws which allow national government to interfere to interfere in the execution of these projects? That we want to be clarified, because we do not, at this point, with the responses of the good gentleman, we are not clear as to what it should be. In fact, in the sponsorship speech of the good gentleman, he says, okay, in the light of these realities, let me quote page 38, it is the view of the committee that it is now crucial to turbocharge the functions and capabilities of the LGUs in addressing road congestion and creating a balanced transport system. So again, it is in that context, what do we exactly intend to achieve by this bill? Do we empower them, the local government units, without regard to the present regulatory framework? Or are we just encouraging them to get into these projects and still be subjected to the regulatory framework that is found in the present law?
Yes, Mr. President, that's a very good question. But if the good gentleman would look at the proposed measure, the word "shall" is expressly mentioned. All local government units shall endeavor to provide.
Allow me to interrupt, sir. Shall and yet endeavor. In other words, what is required of the local government is to plan out and come up with and attract investors in this area. That's how I understand the provision. Unless and I do not understand it to mean that the local government unit can now use it's obliged to come up with a transport system using local government funds. So it's just we're trying to clarify, Mr. President, what exactly is meant by this proposal.
Yes, Mr. President. The word referred to a while ago by...
Shall endeavor.
Yes, the word mentioned a while ago by the good minority leader is consistent with the word I mentioned during my sponsorship speech, which refers to turbocharging. It will unleash the creative, innovative spirit of LGU, especially in answering the necessity, the need to answer not just the present, not just the current transportation requirements, but even future requirements of a local government unit. And precisely, Mr. President, this bill is addressed to the highly urbanized LGUs, which would give them the legal cloak insofar as entering into agreements with private transportation, mass transportation companies, which right now is not present, Mr. President, because if based on experience, Mr. President, if an LGU, for instance, Cebu, would want to have its own monorail system, even if we have a back-to-back city council resolution coming from two city administrations, no foreign investor or partner would endeavor to enter, because there seems to be a legal obstacle here. We are precisely in a twilight legal zone, Mr. President, because while they have autonomy, in reality they don't have, because projects more than 200 million, for instance, Mr. President, they have to go through the NEDA ICC.
So just to interrupt, if the gentleman does not mind, just to bring home the point, and we'll understand what is the purpose here. Will the projects that will be undertaken by the local government units designed to address road congestion and creating a balanced transport system now dispense with the approval of NEDA? Just to be clear.
Yes, Mr. President.
Yes, so...
Yes, Mr. President, specifically...
So they don't need to go to NEDA anymore?
Yes, Mr. President.
Okay. Because to me, we should specify that if that is the policy. That policy, I'm sorry, but I don't read it in the present amendments. I'm not saying that I have objections to that, but I just want to know that that is the purpose. So the gentleman is confirming that the purpose is to empower the LGUs to undertake these projects without regard to the present regulatory framework. Just for the record.
Correct, Mr. President. That's why in the proposed in the amendment there is a phrase there, whether domestic or national without any sovereign guarantee.
No, the sovereign guarantee is
Yes.
completely separate. As pointed out by the good sponsor, presently, if the project is over 200 billion, it will go to NEDA.
Yes.
If the project is over, I cannot memorize.
20 million local sanggunian.
Yes, whatever it
50
is.
million provincial sanggunian.
No,
See,
that is the authorization.
Yes.
I am talking about, say, a project costing 1 billion. Let's say the Makati project, all right. It costs over ₱1 billion. Now, if this law was, firstly, the present project in Makati would require NEDA approval and all that stuff.
correct, Mr. President.
It did so.
Correct,
To
Mr.
the
President.
Now, if we pass this law, that project will not need NEDA approval.
ICC approval. Correct. Mr.
And it can be done by the city.
Correct, Mr. President. Of course, Mr. President, in the law envisions a consultation with relevant national government and transportation planning agencies, and this would involve NEDA for planning, DOTR for intermodal and connectivity purposes. Perhaps the national government has a plan to have a link within that area, so it is envisioned to interconnect future national government projects with what the LGUs will be doing.
I have with this representation, Mr. President, has no problems with that. I will just rely on the expertise of the good sponsor, who is the former general manager of the MMDA,
Chairman, Mr. President.
chairman of the MMDA, to make sure that the intention of the law is clear. Para po hindi magkagulo ang LGU at saka yung national government. Because unless we so specify, right now, projects worth 2.5 billion and above would require approval of the
NEDA
NEDA.
ICC.
First through the ICC and then the NEDA board. Let me highlight this, because if a local government unit, for example, would seek foreign financing without warranties of the national government,
Sovereign guarantee.
the first question that the funder will ask is, have you secured NEDA approval? And the local government will say, no, under section 17 of the measure of the law, I do not need NEDA approval. If I were counsel for the funder, I would not be comfortable with that, because the way I read section 17 or section 17K, it does not imply that NEDA approval is necessary. So I am pointing this out so that we will be clear as to what the intent is. I am not objecting to it, but I'm just pointing this out. Now, having said that, what does the NEDA itself say?
Mr. President, regarding the previous point, for possible amendments, this representation is willing to clarify that in a phrase or two with this proposed amendment to Section 17 at a later date. Mr. President, I received a letter. It's in my folder, coming from the NEDA Director General. It's somewhere here in my files, and apparently, even during the budget hearings of NEDA, I conferred with Secretary Pernia, and they don't have any objection, because all of this as in the words of the President Pro Temp, would catalyze a local build. It will spur regional economic growth, which is supposed to be anchored on the transportation system, Mr. President. So NEDA is amenable, Mr. President.
NEDA is amenable probably with the way it is worded now, because they may have the same reading as I have, that this does not require a change in the regulatory framework, meaning NEDA can be disregarded so long as there is no national fund involved. That could be the frame of mind, Mr. President, and therefore it is best that we clarify what the intention is and what the policy of Congress is by stating clearly what the law is. And, but of course, and so that at that point, the NEDA can react properly. If it's okay with them, we want to hold them to their word and not have it vetoed by the president, because it is entirely possible that they will object to the revision of the regulatory framework and recommend a veto from the president. That is why, to me, Mr. President, it is very important that we state clearly what our intention is, and if we can secure the concurrence of the cabinet, particularly NEDA, then it would be best. But otherwise, we do it by ourselves as a policy maker of this government. Now, still on the issue of the regulatory framework, would the system that is put up, a transport system, still require a certificate of public convenience and necessity?
Mr. President, I do believe that a concurrence coming from the DOTR would still be needed, and under the umbrella probably would come in the LTFRB. That's why, Mr. President, in the bill itself, the consultation process has been highlighted with the national government agencies concerned. My reading, Mr. President, correct me if I'm wrong, is that a CPC would be very applicable for those who are interested in a public conveyance certificate which is being offered to the general public as a privilege granted, but in a situation wherein it's the government itself giving the imprimatur by virtue of this law to the LGUs. I would surmise, Mr. President, that is the general certificate of public convenience itself, Mr. President, the authority given to the local government units to operate is by itself, because surely, Mr. President, in an LGU jurisdiction, there will be no 3, nor 4 or 5 competitors competing in one subway system, unlike perhaps Tokyo Metropolitan Railways, Mr. President. So, in itself, the law will be providing the CPC, my reading, correct me if I'm wrong, to the LGU concerned, Mr. President.
Mr. President, that's a matter that can be subjected to a further study, but under the bill and under the present system, a private sector can be authorized on a PPP setup to operate the transport facility authorized by the LGU. In that instance, where the private sector operates, and given the statement of the good sponsor that the regulatory framework is being set aside, the question is, would the operator of an LGU project in a joint venture or in a build-operate-transfer system be required to secure a CPCN?
No, Mr. President, I'm not directly saying that it should be set aside. The provisions of existing laws, specifically relative to common carriers, the duties...
No, I'm just talking about the regulatory framework.
Yes, Mr. President. That's why in the bill, we never shunned the regulatory powers of the relevant national government transportation agency, but we espouse the international government agency LGU cooperation through a system of consultation. Before you can proceed with this project, let us know. If you, Mr. DTR, do you have a pending plan or a future plan for this route, for this neighborhood, for this highly densified area? So that in itself, Mr. President, will not do away with the regulatory functions of the national government, but it is different with your usual franchise given, for instance, to a bus company. Because here you're talking of an LGU exercising its functions, and with the huge investments involved, probably it cannot be compared with your usual public hearings being conducted by LTFRB or another regulatory agency, even Marina for that matter. So I would suppose, Mr. President, that this is a hybrid empowerment of the LGUs, as correctly stated by the good minority leader. It is born out of the necessity, and then my speech spoke of turbocharging the LGUs concern, Mr. President.
Mr. President, up to this point, this representation is not clear as to whether or not we are repealing the powers of the national agencies insofar as the present transportation system is concerned. We have already pointed out NEDA, the need, the requirement of NEDA approval when the project goes beyond a certain amount. The LTFRB for the franchising, the DOTR, who was the mandate under the law, the MMDA, the LTO. Now, what I'm just saying, Mr. President, is we should clarify the roles of this national agency vis-a-vis the powers that will be exercised by the LGU in relation to the proposed amendment, so that in order to hasten the approval of this act, may I propose that the good gentleman recast Section 17 in order to already enumerate and be precise as to the intent. And we are willing to terminate the period of interpretation for our part, so long as we can go back to the interpretation period for purposes of the amendments that will be introduced by the good sponsor, taking into consideration the debate that we have for the past 1 hour.
Yes, Mr. President, I would seem to agree with the good minority leader that in terms of safety standards, the rail gauges, the systems to be implemented by the LGU in conjunction with the private operator, the national safety standards of a railroad system, or even a subway, even though we don't have a subway yet, should be of national standards, bearing in mind that whatever projects LGUs may propose or implement, it would reflect on the national transport system. So I agree with the good gentleman, Mr. President, that this can be still amended to include the safety standards, the matter of providing the consent of the national government, specifically as to the relevant, if you call it franchise or authority, to be secured first from the appropriate government agency. And in this case, I reckon that to be the DOTR, Mr. President.
So is it the intention to dispense with this permit required now?
No, Mr. President. I'm amenable to the proposal, and that will be part of our amendments to have the permitting process as part, and with due regard to the safety standards. But I would also surmise, Mr. President, that no legitimate even foreign railroad company with a background to speak of would put in place a defective or even a below standard transport system. So, but I agree with the gentleman, Mr. President.
Okay, so Mr. President, in order we can, I am amenable to terminating my interpellation having already drawn from the good sponsor the answers that I would like to hear, although not reflected in my interpretation in the present bill, so that if we can be honored, or we can be given a copy of the proposed amendments, and we understand that we will be permitted to ask questions after the amendments are submitted in order to clarify the intent of the law. We have no problems with terminating on our part the period of interpolation on this bill and await the amendment, which we hope will reflect the discussion this afternoon, Mr. President. Just one more point. Will the law, once passed, also allow or require the local government unit to earmark or to undertake this project on a to earmark local funds for this project?
Yes, Mr. President, it's now the part of the autonomous powers of the local government unit, but subject, of course, to existing fiscal restraints, Mr. President, because there appears to be a 20% cap on the expenditures that a local government unit can
I understand
do for this purpose, Mr. President. So, but as regards the amendments, I willingly, Mr. President, we will provide the good minority leader the amendments as part of his interpellation, Mr. President.
Under in existence today is Memorandum Circular number 2016-120, or the guidelines for the implementation of the public-private partnership for People Initiative for Local Governments, or they call it LGU P4. This circular expands the modalities for public-private partnerships beyond those provided in the BOT law. May we know if this will still apply once the bill becomes the law?
Yes, Mr. President. The cited regulation probably will be superseded insofar as the transportation aspect is concerned. But as regards slaughterhouses, municipal libraries, city hospitals and clinics, that would still be applicable, Mr. President, because this bill is anchored on the transportation problem which we are experiencing right now, and which we will still experience in the near future, because I've stated this several times over, that there is always a threshold of urban congestion and population. And most of our growing regional urban centers and cities, in the Visayas, of course, you have Iloilo. In Cebu, you have Cebu, Lapu-Lapu, Mandaue Growth Center, the Angeles, San Fernando area, the Butuan, Cagayan de Oro, Davao area. Of course, not to mention Metro Manila. Will have to be, will always be confronting this problem of traffic congestion. And we really think, Mr. President, that it's not only because of the transport demand, which exceeds the transport supply. We really have to prepare. And I think it behooves upon the Congress to prepare through the appropriate legislative measures on the measures that we should be doing 10 years from now, doing it today, Mr. President. And I thank the good minority leader for allowing me to expand this by specifying the provisions that would really be needed to avoid the uncertainties, so to speak, in case this might be subjected to a judicial question, Mr. President.
All right, with that understanding, Mr. President, we can terminate our interpellation on the understanding that the amendments will be advanced, will be given to us in advance, so that we can raise questions on during the period of interpellation or in the period of amendments in order to clarify the new regime once the bill becomes law. With that, Mr. President, I manifest that we no longer have questions at this stage.
Thank you, Mr. President. I thank the good minority leader himself for the very enlightening clarificatory questions. Thank you, Mr. President.
Thank you to the
Majority
good
Leader.
gentleman, Mr. President of the floor. With that, we move to suspend consideration on, suspend, wala nang magtatanong. Wala nang magtatanong. Well, no other members, Mr. President, wishes to interpolate the measures. Therefore, I move that we terminate the period of interpellation. I so move, Mr. President, with the permission of the body. Without prejudice to asking questions, live rhetoric questions during the period of amendments. Yes,
All
Mr.
right,
President.
any objection? Hearing none, period of interpellation is closed.
I move to suspend consideration of Senate Bill number 1211.
Consideration of the measure suspended.
Mr. President, with that, I move that we adjourn session until 3 o'clock in the afternoon on Monday, January 27, 2020. So move, Mr. President.
Any objection? Hearing none, session is adjourned until 3 o'clock in the afternoon of Monday, January 27, 2020.
Thank you.